All right, no one's on the telephone, okay. All right, the next hearing is in connection with LL Plaintiff versus Volusia County, Florida, and Monica Willard as personal representative of the estate of Carl Pete Willard, deceased defendants. This case 2012-13199. We're about 10 minutes delayed in getting started. And I apologize for that. We're just running a little bit behind on our hearings today. I also want to advise everyone, apparently it should be obvious to everyone, but someone is recording and potentially making a visual recording of of this hearing. These are hearings that are open to the public, like almost all of mine, and so I freely allow that as long as everyone is advised ahead of time, so people are not being recorded and don't realize it. But with that caveat, if it's not disrupted, I generally allow anyone to sit in and therefore anyone to make a recording of these public proceedings. All right, this is the motion to dismiss. So who wants to lead off and supplement, if you wish, the written motion?
Yes, Your Honor, Nancy Jones on behalf of the County of Volusia. I have a motion to dismiss.
You may stand or sit as you choose.
Thank you, sir. I have a motion to dismiss, as well as I believe Mr. Wallace and Mr. Smith, representing the estate of Deputy Carl Willard, have a motion. We argued this before Judge Zambrano already, so we did a tag team before, and to the extent that my issues are briefed, I believe pretty specifically in my motion, I'll just touch on those briefly and save time for Mr. Wallace and Mr. Smith. This is a 5-count complaint. Well, it's 5 counts against the County of Volusia, against the county as well as Deputy Pete Willard's estate. With regards to the County of Volusia, the plaintiff has alleged in the complaint that while en route to jail, the relevant parts of the complaint allege that while en route to jail, Deputy Willard was taking the plaintiff to jail, that he essentially digressed or went into a secluded area and, I quote, sexually assaulted, battered, and molested her while she was in handcuffs. It's also alleged in the general allegations that he fondled, touched, or caressed the plaintiff, but that sexual battery intercourse did not take place because she didn't succumb to that. There are 5 counts against the County of Volusia. 4 are tort counts, and the 5th is a 42 U.S.C. 1983 claim. The 4 tort counts we believe should be dismissed, Your Honor, based on the 768-28, the sovereign immunity of the county. The allegations in this case are simply that Deputy Willard sexually assaulted and battered Ms. Lopez while en route to jail. And so we believe that the case law we've cited, as well as some other cases, I didn't cite every case I found, Your Honor, but there are others that basically say a sexual battery is never going to be within the course and scope, essentially. So it's our position that, based on the allegations in the complaint, it's not a sufficient cause of action is not alleged because the county enjoys sovereign immunity. Couple of quotes I just wanted to mention, Judge, is that with regards to the scope and employment, we don't dispute that Deputy Willard was in uniform and in a patrol car and was initially in the course and scope of his duties taking her to jail. But based on the allegations of the complaints that he drove to a secluded area and sexually assaulted and battered her, there's no scenario where that could be considered in furtherance of the employer's job or the employer's requirements. The purpose of the Employees Act should be looked at. In this case, the purpose of, if you take the allegations in the complaint as true, as you have to do at this stage of the proceeding, an employee is not acting in the scope of employment if it can be found that the employee has stepped away from the employer's business at the time of the infliction of the tort, and that the motive was unrelated to the employee's duties, but rather was in furtherance of the employee's interest. Then the county cannot be liable under that scenario, and we believe the facts as alleged in this complaint fall right within that.
On the sexual battery always being not within course and scope, and therefore not actionable against the governmental employee, has there been any case law since the Mason case out of the 5th District which in any way calls that into question?
Let me look at, Mason was 97. Not that I found, Your Honor. The only case that I found which was not out of the 5th and actually is cited in the McGee case and I'm trying to put my hands on it real quick, and that's the I think it's pronounced the Hennigan case. And actually, sorry, it was Hennigan that I was quoting from about the employee stepping away from the employer's business. And Hennigan was a 1985 case, so not since the fifth case, Your Honor. And that was a first district case, which I think is factually distinguishable. The other case I rely on in my brief was the Casey case, which is a federal case, Your Honor, but it clearly says it had similar facts in that the officer had arrested the plaintiff, was taking her to jail, and he drove down, or I think he drug her down a dark alley is what's alleged or what's asserted as the facts in the case. And he, similar factually, he fondled her, no sexual intercourse took place. And the Casey case specifically says that that is not within the course and scope, the sexual assault of that nature. In addition to that 768-28 argument, Judge, that we have sovereign immunity is in counts 2 and 4, which are an intentional infliction of emotional distress as well as a negligent infliction of emotional distress. The allegations in the complaint are that even as to the negligent count, the allegations are that the conduct was outrageous and extreme, deliberate, and under 768-28, that definitely would not be within the course and scope and would the county would be have sovereign immunity under those counts for that additional reason, not just the sexual battery issue. The fifth count against the county is a 1983 count, 42 U.S.C. 1983, Your Honor.
Well, let's go over the, let me let plaintiff's counsel respond to the court claims first. All right, sir?
Thank you, Your Honor. I think obviously the controlling case.
And just since we have a court reporter in the court making notes, if you would state your name.
I'm sorry, I apologize, Your Honor. John Dill, representing the plaintiff.
All right.
Your Honor, I think the controlling case, at least as far as the overall 768 analysis, is the McGee versus Volusia County case. I have a copy for the court and proposing counsel.
Thank you.
And specifically, Your Honor, I think the McGee case, again, a Supreme Court case, focuses on the abuse of power, essentially. And in that case, the Supreme Court reversed the Fifth's upholding of the motion to dismiss, stating that in that case, the fact that Herndon may have intentionally abused his office does not in itself shield the sheriff from liability. In sum, the question must be put to the fact finder whether Deputy Henlon acted in bad faith with malicious purpose or in a matter exhibiting wanton or willful disregard for human rights. The Mason case, which was decided short, I'm trying to figure out time-wise, but it appears as McGee's doesn't appear to be cited in the Mason case, but the Mason case is a coverage case having to do with the sheriff's fund, whether or not the judgment that was stipulated to would have been covered. And in the Mason case, in cases they were citing Mason, you're talking about whether it was covered under their insurance policy. It's a lot different.
Right, but they weren't a construction of insurance policy case. They were talking about when a governmental entity could be liable, were they not?
Well,
you can't get around that from Mason, can you?
I'm not sure if I can get around it from Mason. I can just look at the four corners of what's in Mason, and it's talking about construing the course and scope of employment. I just think that...
Well, how about 768-28, which says that the waiver doesn't apply unless, if the actions are, the statute can read it.
Right, outside the course or with malicious purpose.
In a manner exhibiting wanton and willful disregard of human rights or safety. You flat out alleged that this was in a manner which was outrageous, extreme, and in total disregard of this woman's human rights.
I do allege it because I have a 1983 count as well against the county.
But you don't just allege it in 1983, you allege it in various court actions against the county. Court actions, not 1983. You said, paragraph 16 of your complaint, the actions of the deputy, quote, were extreme, outrageous, oppressive, and done with the intent to cause plaintiff severe emotional distress, close quote. Right? Where in the complaint do you ever allege that this sexual assault battery is somehow less than extreme, outrageous, oppressive, or something less than a wanton and willful disregard of human rights? I mean, can't we all agree that sexually assaulting a woman is all of those things?
We can, Your Honor. And as far as the counts, I agree with that point, Your Honor. The counts weren't just for the battery. We also alleged false imprisonment as part of it, which is one of the counts as well as the negligent imitation.
But all the false imprisonment was in the same transaction of events, the same, with the same intent to sexually assault and batter this woman, correct? I mean, that's why he kept her in the patrol car and deviated from his course to the jail or wherever he was supposed to be going. And this is all the allegations. I don't know what happened. We have a trial case, but the allegations are he did this intentionally, and he certainly assaulted her and molested her intentionally, right?
That's the allegation.
Well, how can that not be in a manner exhibiting wanton and willful disregard of her human rights and safety? How can it not be?
I guess the issue, Your Honor, like the McGee case says, that's for the fact finder as opposed to an motion to dismiss. And that's what my argument would be. That's the Supreme Court case law.
I think where you're talking about potential excessive force, maybe someone used too much force in subduing someone, all those things might be judged in the eye of the beholder, but can you tell me how any reasonable juror, much less an entire jury, could conclude that if what you have pled is true, that somehow is not done in a manner exhibiting a wanton and willful disregard of the rights, the human rights of your client?
No.
Just tell me how they could do it.
I can't.
I can't fathom it.
No.
So
based upon that question, no, Your Honor.
And if that's true, then the very words of the statute say that in those cases, the governmental employee is the one that's going to be held liable, where it's willful, wanton, extreme conduct. In those cases where it's within the course and scope, you can't even name those employees. You have to sue, normally, the governmental entity, and they have to pay for whatever that, excessive force or false imprisonment or whatever else was done that shouldn't have been done.
Well, I guess the problem is the McGee case talks about the abuse of power being different, a little bit different. And that's, I think, what we have here. It's a situation where he's abusing his power as opposed to going off and doing something solely on his own. This was within, certainly, the transport, which we've alleged in the 1983 case was not appropriate. This is within the course and scope of transporting her. So based upon what McGee says, that the abuse of power and the fact that someone abuses their power does not automatically mean that the exception to 768 applies.
I might agree with that. It's just an overarching kind of general statement or even a characterization of the McGee case. But in count one, I'm just going to go through it one more time. I'm not trying to beat it to death, but I want to make sure I'm not misunderstanding. In paragraph 12, you allege that the actions of the governmental employee included but were not limited to unlawfully fondling, and then it repeats that, and fondling plaintiff's body against her will and without her consent. In count 2, which is count 1's the assault and battery against the count. Count 2, the intentional infliction of emotional distress against the county, which is the tort of outrage, sometimes called, which is kind of instructive, really, I think, to us. But you don't call it the tort of outrage, as it could be called, but you also say that the actions of the governmental employee were, quote, extreme, outrageous, oppressive, and done with the intent to cause severe emotional distress, period, close quote. And then in count 3, the allegations in paragraph 19 are that the governmental employee unlawfully and illegally imprisoned and held plaintiff against her will while sexually assaulting, battering, and molesting the plaintiff. Again, not just some kind of improper false imprisonment that maybe wasn't really intended, or was simply an abuse of authority, holding someone longer than they should have been held, or something that maybe reasonable people could differ or discuss. But holding her while sexually assaulting, battering, and molesting her. And then count 4, even under the negligent infliction, talk about the actions of the employee, and there's only one we're talking about, was extreme, outrageous, with total disregard or deliberate indifference to the constitutional and civil rights of the victim, the plaintiff. So those are all of the tort counts against the county, I believe, yes. And I just find that all of those, I don't know, need to go any further. I don't believe them to find that all of them are specifically the county has not waived sovereign immunity for those matters pursuant to 768.28, because it says that they don't waive it where the acts or omissions are committed with malicious purpose, left that one out before, or in a manner exhibiting wanton and willful disregard of human rights or safety. So I think all of those things not only apply, but are pled to apply.
I understand the ruling, however, I did allege inside the course and scope within each of those paragraphs.
That's a legal conclusion, yes.
But again, we're looking at the 4 corners of the complaint, Your Honor, respectfully. If I'm alleging he's in the course and scope of the
We're looking at the well-pled ultimate facts contained within the 4 corners of the complaint. All legal conclusions are not necessarily going to be accorded any deference at all.
But I understand the court's ruling on that. We never alleged willful or wanton disregard of human rights, but nonetheless, I could see how interpretation of that would lead to.
All right. Well, I'm going to dismiss those then, and unless you want to amend those counts. I think you've already done it, what, twice?
Well, I haven't amended the counts, Your Honor. We amended the complaint because we sued, it's Volusia County's the proper defendant, not Ben Johnson. If an amendment, I'm not going to do an amendment.
This was a second amended complaint. I didn't go back to look for the complaint or the amended complaint.
That had nothing to do with the allegations themselves.
Well, do you want to try to re-amend? I mean, I don't know how you're going to.
Your Honor, I don't think it's.
I think you've made your record and you can stand on these allegations if you think that I'm wrong because of McGee versus Volusia County or any other reason.
Without waiving anything, I don't think it's necessary to amend based upon your ruling.
Very well, then those will be dismissed based on that representation with prejudice. Now, what about I'm a little more, less opinionated, I suppose would be a good way to put it. I'm a little less ready to weigh in on the civil rights cause of action contained in paragraph number, is it 9, 8, 7?
It's count 7, I believe,
7.
Judge.
Let me find it.
Yeah.
Yes, count 7. 42 U.S.C. section 1983, count against defendant Volusia County. That's often referred to as civil rights, based on failing to supervise and properly train, failing to enforce the laws of the state of Florida. Is paragraphs A through E there, failing to promulgate policies and procedures. The one I'm really concerned about is an allegation that at least may have some factual, common sense application is E, the one that says you should not have, paraphrasing and maybe not accurately, but you shouldn't have single male deputies transporting female detainees without supervision of the presence of a female, I think it says, but you should have at least 2, I don't know. But the rest of them I'm not sure really rise to anything because I don't know how it could even be argued that deputies don't know that it's inappropriate to will or to with extreme disregard and with deliberate indifference sexually assault, batter, and molest a female detainee. I mean, I can't imagine that anyone has to be told that, or that could be the law, that we have to have specific instructions not to do that, or they won't know not to do that. I think that would be, I just don't think any court's ever going to come to that conclusion. And maybe Mr. Bill can give me a case where proves me wrong, so we'll see. But let me ask you, Ms. Jones, tell me why, at least on that score, there isn't some kind of violation of civil rights or something?
Your Honor, what I'm prepared to say is that they may be able to assert such in another attempt at this, but as presently pled, I don't think they have properly alleged a 42 U.S.C. 1983 violation against the county. If they're going on the failure to train, which I think you've already sort of given me a thought how you feel about that, there's insufficient allegations. They have to either allege a widespread pattern of abuse that put the county on notice that we should have more training on this, or there would have to be an allegation that Deputy Willard himself had engaged in such conduct, the county knew about it and still didn't train him properly. On the assertion that they don't have a policy, or that we don't have a policy, if you read the complaint in totality, Judge, or at least that count, they allege on the one hand we do have a policy that's insufficient or that we don't have a policy. So I think it's a matter of the failure to properly plead the 1983 count by showing what the policy is that we did or didn't have. They have alleged that E, as you said, but also how that resulted in the violation of her constitutional rights. They have to show and allege a causal connection between those two things. And I think that based as it's currently written, I don't believe it reaches the minimum requirements to allege a cause of action under 42 U.S.C. 1983.
But you seem to intimate that possibly this could be amended so as to state a cause of action under 42 U.S.C. And I think you're saying they can, but you wouldn't say that it's necessarily impossible.
Not as to a failure to train. I do not think they can assert that allegation. I don't think they have sufficient.
What about their policies and procedures?
It's possible without going out on a limb, Judge.
All right, Mr. Bill.
Well, Your Honor, let me just say the same form of complaint I used many times in 1983 cases, and as far as whether it states a cause of action based upon
In sexual assault, 1983?
more in the police shooting or excessive force cases, which I'm just going off what I
Right.
generally
And
do.
again, I'm not trying to just warning on your time here, which we're woefully short on, but I can really see a difference between training people when to use lethal force with their firearms, when not to, when to chase with 4,000-pound vehicles and where and not to, and many other things that might be in the excessive force realm or otherwise. But I'm having real trouble talking about training people that they should not sexually molest females.
Well, and Your Honor, I think at some point, if we get to a summary judgment standpoint where they've been adequately trained and there are policies and there is training and there is, we just don't know. I've alleged
What would
this.
the training accomplish?
Well, I assume the training would accomplish is don't transport a female.
No, but let's put that one aside. But as far as you shouldn't sexually molest, you're not, some of this, if you just read it as it's written, when you address this case, when applied to this case, it seems to allege that they should have taught deputies that they're not supposed to assault, batter, and molest females. Well, you didn't need to say that, did you?
Well, sir, I think what I said was failing to supervise properly the training and conduct of the sheriffs so as to prevent sexual assault, failing to enforce the laws.
Well, you also said failing to, okay, maybe I misread it, failing to enforce the written rules concerning the use of force on female. Okay. All right, go ahead, I'm sorry, I interrupted you.
And I guess that's what I was driving at. As far as the allegations of proper training, we haven't had the opportunity to do discovery on all this yet. And it may be that the only issue is failing to implement a policy of transporting with a female, which I believe is recognized by many different law enforcement agencies. And I
Do
think,
they have one or don't, or you don't know?
I don't know if they do or not. I think for some reason, I
You said we
think,
haven't had a chance. We've had at least a year, because this is well into 2014, and this is a 2012 case. So haven't we had at least a year? Did you not serve?
no, I haven't served that, Your Honor. I mean,
No,
obviously,
did you serve the county pretty quickly, or was there a big delay? Because
there was a bit of a delay.
we're in our third calendar year of this case.
We amended the complaint, Your Honor, we didn't serve
You
it.
did discovery when you did.
Well, Your Honor, this is a motion to dismiss.
I understand, but you were the one who asserted you hadn't had the opportunity to do any discovery, and I'm sorry, that was jarring to me. I had to ask about it. All right.
I guess opportunity is not the right way to say it.
Okay.
Discovery hasn't been done.
Just hadn't been done. All right, well, those things happen.
And so I guess the main issue is going to be I will concede the main issue, unless something else comes up through the discovery, is going to be this policy and procedure of transporting a female deputy with a male deputy.
All right, thank you. I'm going to dismiss the count against the county for 42, that's count 7, premised on 42 USC, but certainly would leave them in. You tell me how long you want.
Oh, Your Honor, I'd like 10 days if possible.
Sure. You would get 10 normally automatically, so if you wanted more, I'd have to give you
Well, if
All
I
right.
could do 15, then, Your Honor, that'd be
That'd
fine.
be
And
fine.
that's without prejudice as to what's, with more specificity,
Well, I just don't think it states a cause of action, so yes, if you will work on it, if they have a problem with it, we'll come back, and I'll try to be more specific, but I don't have much time today. All right, let's go then, and we're well over our time already, and even though we started a few minutes late, but what I'm concerned about, either Mr. Wallace or Mr. Smith, and you don't need to stand unless you wish, what about this never presented a claim in the probate? Do you think, because if that's true, is that dispositive?
Yes, Your Honor.
All right, well, tell me about that one, educate me about that. And is it dispositive also to the civil rights?
Yes, Your Honor.
All right, fire away.
The argument is pretty short, Your Honor, so I think I can help with the time part. It's highly technical, but short. In order to make a claim or a cause of action against the estate, you need to follow two statutes, 733-702 and 733-710. 733-702 is referred to as the claims statute commonly. And that's the statute that authorizes the claims procedure in an estate. You do publication and you file a claim in the estate, and then if it's objected to, then within a certain length of time you have to file an independent action an action independent of probate. The other statute is the drop-dead non-claim statute, which says if you don't do something within in the probate within 2 years of date of death, then that's it.
Now, does that include even where there's insurance that covers the situation? Does insurance have anything to do with this?
No, it would not include the insurance. If there is an insurance exception, as Your Honor points out. I'm not aware of any insurance in that. I mentioned the exception in the motion to dismiss with my representation that I'm not understanding that there's any insurance.
Well, that brings up a point I was trying to
Okay.
get to, very obtuse way, I guess. But wouldn't this be better pled as an affirmative defense, since he clearly seems to state, I say he, the plaintiff's attorney, I should say, the plaintiff clearly seems to state a cause of action otherwise, or at least has one, whether you agree that he stated it or not. And wouldn't this be kind of like a statute of limitations defense, which, while it can be brought as a motion to dismiss, it's usually better brought as an affirmative defense, so there could be a reply to it, for example. The reply might be, oh, there's insurance here, or it was told in some way. Can you tell that one? But anyway, there might be some avoidance of the avoidance.
Not in this instance, Your Honor, although I agree with you as a general proposition that statute of limitations are often appropriately affirmative defense.
Usually.
Yes, usually, often, most often.
What the appellate courts tell us.
Yes.
It's an exception to do it by motion to dismiss, although it's been done.
But the disposition of assets in probate administrations had a strong public policy behind it. If you don't do something within 2 years, it's drop dead. And the only exceptions to it have to be brought in the probate administration by statute. So if you're saying that, for example, if the plaintiff would say, the plaintiff didn't file anything in the probate, and the probate's been dismissed and the personal representative's been discharged. Okay. If the plaintiff is saying, what we want to do is reopen the estate and
make an insurance-covered claim. They should
well,
go to the probate to do that.
extend the time to file a claim, there are only 3 grounds that you can do that. Insufficient notice, a fraud, and estoppel. But those are within the exclusive jurisdiction of the probate court. And there's no cause of action here because they haven't alleged any compliance with these probate limitations or notice periods. They haven't said, we want to do this. It's on its face. You can't bring a cause of action against an estate. Now, this claims procedure applies even if there is a pending claim, even if you already have a judgment. You still have to do these things in order to preserve the right to get the assets of the estate. And no federal preemption. I have a case for Your Honor on that. Certainly there is the doctrine of federal preemption, but in this instance...
Oh, I'm painfully aware of that doctrine. I guess trial judges in state court should like that.
Compliance was possible, is the bottom line here.
Okay. Well, thank you. You've been relatively succinct, especially when compared to other people who have argued in front of me today. And it's really not been their fault. I've struggled to understand certain matters, and sometimes that takes a while. So, Mr. Smith, did you need to weigh in on this?
Mr. Wallace said it even better than I could hope to.
All right. Well, thank you. All right, Mr. Bill, they say that you didn't present this to the probate court.
Your Honor, I guess as far as the motion to dismiss, none of this is, it's all outside the motion to dismiss as far as what was presented, what wasn't. But leaving that aside, the personal representative was served with a complaint. Actually, served in October, and there was a federal complaint originally, and then through discussions, it was dismissed in federal court and refiled in state court. We never defaulted them. They were served with a copy of the complaint. Additionally, it seems like they waited until the time period expired and then raised this. Certainly, the estoppel argument would go to that. But most importantly, I think that certainly as far as the 1983 count, and potentially there's a factual issue as far as the other counts as well, but certainly as to the 1983 counts, it's preempted by the case of Felder versus Casey, the Supreme Court case. And I just got a copy of the Borax case now, but I've given opposing counsel this case last time. Felder versus Casey, where a notice of claim statute, a Wisconsin notice of claim statute was preempted because it was inconsistent with the federal civil rights claim. The 1983 claim has a 4-year statute of limitations. This would, if the bar date is applied to that, that would preempt the federal law as far as the 1983 claim itself. But again, I think Your Honor puts it well with the first question or the first inquiry. I believe this is a factual issue as far as when they had notice of the claim. If they're saying that we have to petition the probate court to collect on a judgment or to inquire as to whether there's going to be insurance that's available, there could be an issue. Honestly, in these type of cases, usually it's the county that ends up providing insurance to the officer. So as far as whether there's a factual question as far as an exception, I don't think that's appropriate for, I would say that is not appropriate for a motion to dismiss.
I don't know in Volusia County if they do that or not, because I have practiced as a lawyer a long time. I can't remember it coming up, maybe it has, but in cases before me as a judge over the last 19 or 20 years. But I seem to remember years and years ago, the county was basically self-insured for most of these things, so I don't know if they have insurance or not, but that's not for today. All right, did you want to reply? Is this where we have two different federal cases that conflict one with the other?
I didn't hear the cite on the case.
I'm sorry,
I'm not familiar with that. So
You don't have your copy, I think.
Yeah, it's a United States Supreme Court case, Felder versus Casey.
He thinks that trumps your federal court case. Of course, it is, I noticed, like in the other argument, your case is more recent than his, so I don't know if it cites and distinguishes, your Borax case distinguishes the one that Mr. Bill was giving me, or if they just conflict or what. Of course, if they conflict, and they are both apply to this case, then we would have to go with the Supreme Court. So, are you familiar with this case?
I'm not familiar with this case, Your Honor.
All right, well, I just think that this is normally a matter for an affirmative defense. And I know that if it's a slam dunk, you can't bring it. It's frustrating for lawyers to just kind of kick the can, have the judge kick the can down the road. And I know you feel strongly that you're entitled to dismissal at this point. But I think rather than that, I will deny it, recognizing, and we have the court for you here, that it's possible that I should have granted it. It's possible. But I'm going to retreat to the usual way of practice, which is you raise these kinds of things by affirmative defense. And as Mr. Dill points out, there's probably good reason for that in many cases. There may be some factual issues here that he will want to raise in response to your affirmative defense that he might think somehow negates your affirmative defense or vitiates it or avoids it or something. So, just in an abundance of caution, I think if you're right, it delays it a bit, probably come back on a summary judgment or otherwise, or judgment on the pleadings. If you're not right, then of course it's a good thing I didn't grant your motion today. So, all right, well, who
Judge,
wants
can
to-
I ask one more thing on
Oh, I suppose.
quickly? This initials in as plaintiffs, I cited a case that says it's not appropriate, so if he amends
Oh,
or
yes, he's got an
refiles.
amend. I'd forgotten about that. What authority do you have for, I read an interesting article one time years ago, not that many years ago, about the use of John Doe in so many pleadings, and my vague recollection is the author didn't think much of it, so can't find it anywhere in the rules of procedure or placeholder parties and things like that. That's a little different than this. I understand the desire to have this person maintain as much privacy as possible and to not be named in a case with these kinds of alleged facts. On the other hand, I don't know of any rule or law that permits someone to travel with a pseudonym or under initials in a case like this.
Well, I guess what would the harm to the defendant be in this? They know who it is, they're on notice, they did an internal investigation. Obviously, it's a sexual assault victim. If your Honor's going to require that I do
It's
it, I'll
really
do
not,
it.
it's not a question of harm. I mean, it's just, I can think of a lot of things that we could do that wouldn't be in accordance with the rules that I could probably think wouldn't cause any harm, but I just get worried when if they brought it up, if they didn't care, I'm not sure I would care. I might not ever even notice it.
If there's some authority, I'm happy to look at it, Your Honor. I mean, if there's a case saying that it's inappropriate to bring initials, I'm happy to do it.
It's
I
cited
dealt.
in my response, my motion to dismiss, it's cited in a footnote. It's
She
not appropriate.
cites the case.
And as he mentioned, she made an internal complaint, and all
Well,
of those
I-
documents are public record as
These
well.
documents are all public record, and her name is known to the public with even a tiny modicum of investigation. Again, I see no harm in requiring her to follow the same rules everyone else has to follow, which is to sue under your name. So I'm going to require that on you, and then this third amendment complaint.
Okay.
All right, anything else then that we need to cover today?
As far as the order, I'm sorry, Your Honor, as far as the orders, do you want me to prepare all of them, or does it matter to you?
Whoever wishes to, I really appreciate it when lawyers help me.
That's what-
Ms.
Unless you
Jones
want
says
to.
she'll be happy to do them, but of course she's going to run by you and make sure that they're, meet with your approval as to form. As to content, I've already made my correct or incorrect rulings. Let's just hope all we're worried about is that the orders reflect our rules. Anything?
As to time, Your Honor,
She said 15 days he would like to amend.
from the date of the signing of the order.
Sure.
Okay,
And,
that's
you-
fine.
You would
That's-
have, you would
that-
normally have 10 days from then. Do you need more time?
Well, I'd be responding to the complaint.
Right.
So let's make it 15 days from the date of signing of the order, the same thing.
Well, I think you should wait till he files his amended complaint. I see no reason for you to be, well,
Okay.
because the
All right.
count numbers are gonna be different, don't you
Okay.
think?
Yes, sir.
There's no rush in you.
All right, okay.
Why don't you, he's gonna file his complaint, next amended complaint, within 15 days of the date of my order, which will cause everybody to get to me quickly at it. And then within, is 10 days long enough after he files his?
Yes, it would be.
Okay, then that, we don't need to say anything because that's automatic.
So I want to make sure this is clear. I'm doing one order,
I see no reason to do more than one.
okay, and it's going to dismiss with prejudice the 4 counts against the county, allow them to amend the other count against the county, deny as to their motion to dismiss,
Right.
the state's motion.
Give them 15 days to
amend.
amend, and everyone, including them, 10 days from when he amends to respond.
Okay.
And I guess put in that I'm going to do the third, you don't have to put it in, I'll just put in her name as far as the,
Well, it's of record, so, I mean, there's a court.
it's not necessarily to put it in there.
Okay.
But I'll put her name in there.
All right, thank you one and all. I appreciate
Thank you,
your
Your
help and your support.
Thank you, Judge.
Thank you, Judge.